Please rise. Court is now in session.
All rise. All rise.
Is It Legal Too? A regular look at the legal system and you, a special production of the Missouri Bar. I'm Bob Priddy.
And I'm Farrah Fite.
Farrah, the other day I was driving along one of our busiest streets, and I had to stop because traffic had backed up from the drive-through window at the marijuana dispensary.
Really?
Yeah. I thought the legalization of recreational marijuana would draw a lot of people, but I've been surprised by things like this.
I've also been surprised on a recent trip down to South Central Missouri, where I grew up with my dad. I was a little surprised to see a row of dispensaries in my hometown, which growing up there, I never envisioned that there would be such a thing.
Yeah. So let's talk about this today and explore the law and some of the early issues that are attached to it.
We've invited one of the first Missouri lawyers to focus on legal issues of legal marijuana availability, and he's here to join us today. He was also a guest a few years ago when we discussed medicinal marijuana on one of our early episodes. He's Eric Walter, who is with the St. Louis law firm of Armstrong Teasdale. He's a former assistant attorney general for Missouri, and he's been watching marijuana for most of the last decade in Illinois and in Missouri. He got into this line of work when he was asked to review an employment contract of a man wanting to be an officer of an Illinois company who is applying for multiple medical marijuana licenses in Illinois. He's the outside general counsel for MoCan Trade, the Missouri Cannabis Industry Organization, and he also heads his law firm's marijuana and hemp law practice area, which I wonder how many law firms actually have that practice area.
Interesting. Our second guest is Amy Moore, who's the director of the Cannabis Regulation Division of the State Health Department. She joined the department just after voters approved medical marijuana, and the medical marijuana program now serves more than 200,000 clients in 400 facilities. She took over her new job in November of 2022. So we're welcoming both of these people to our program today. Amy, welcome to you.
Thank you.
And Eric, we're glad to have you back. As a reporter, I covered, decades of efforts to legalize marijuana, first for medical use and then for recreational use. I recall times when marijuana promoters were even displaying shirts made out of hemp to show that the weed was safe. What do you finally think turned the corner on legalizing marijuana, either for medicinal purposes or now for recreational purposes? What was the break point, do you think? Eric?
For me, the break point was probably had to be California, the first state to legalize medicinally in 1996, I believe was the year. That was really the first concrete step towards, I think, manifesting the feelings of this community, I think a minority of individuals who just didn't understand the war on drugs, didn't believe in the prohibition on marijuana in particular, and just weren't willing to comply with the legal constraints. And so there was this sort of grassroots movement. And in that sense, it's kind of a cool aspect of democracy that in the end, the people, I think, sort of rose up, and they're still, the process is ongoing with the federal law, but they rose up and they said, this shouldn't be legal, and here's why, and we're just going to persuade you. And over the course of decades, that persistence paid off.
Amy, do you have anything to add? Or?
Yeah, I think Eric's right about where it all began, and I'd say it's one of those snowball effects, picking up speed, and in the case of this issue, picking up acceptance. And so as more and more states passed some version of legalization, it became, there's a cultural shift there. It became more accepted so that even eventually Missouri could accept this as more the norm rather than this radical thing that California did back in the day.
Is possession or use of marijuana still illegal in any way in the state of Missouri now?
Amy, do you want to start?
Sure, I can answer that. Yes, the answer is yes.
Okay.
There are limits on possession amounts. There are limits on purchase amounts. They're different for the medical program than the adult use program. These were all written into the law that passed here in Missouri. There's also some really important things to understand about how you can pass cannabis between people. It's certainly legal to purchase it at a licensed dispensary. It also is legal to gift it to someone between individuals up to, I believe, 3 ounces. But it is still not legal to sell between individuals. I think that's something that we're seeing right now, a little bit of confusion about. You might, for instance, go to your local farmer's market this past summer and see somebody set up with a booth with the product that they had grown, selling it. That is still not legal. So, we at the Department of Health are working on communication about that, both to our the individuals who are licensed to grow with us, communicating to them what their responsibilities are, but then also just to the general public to ensure that people don't get themselves into trouble.
Right. Eric, with the industry representation that you have, what challenges do you see there with what's legal, or the understanding of what is legal and what is not?
Well, my clients, I like to think all my clients know what's legal and not. I'm able to advise them, but I think it is a challenge for them. It's a very competitive marketplace. The tax environment is very unfriendly because of the illegality that persists at the federal level, and that means that they need a certain amount of market share to be viable, to be able to spend the money to have the people to maintain compliance, to maintain the security requirements that go with being in this highly regulated industry. So it's a real challenge when a segment of the market is competing against them, but doesn't have the same constraints, the same obligations, the same responsibilities. It really does create a problem, because it is, by far that the largest seller of marijuana in Missouri and everywhere else is still the illicit marketplace. And so some of these individuals are sort of trying to take on some kind of a sheen of legality by saying, well, we have a license to grow at home. Well, yeah, but that's only for that person's personal consumption. It's not meant to be an opportunity to become a sort of a miniature, drug trafficker.
Are there any legal limits on how much a person can grow, how big a plot you can have, or how many acres, I guess, even that you can operate a marijuana farm with?
Yes, there are. Mm-hmm. So anyone who wants to grow cannabis on their own needs to, whether it's for medical use or adult use, non-medical use, mm-hmm. they need to apply to the department for a card that can show that they're authorized to do that. But there are limits on how much they can grow. I try not to relay those amounts because there's layers of numbers depending on if you're a medical or adult use, and then there's also regulations about where you can grow that and whether or not it can be visible by your neighbors. There's quite a few requirements that our licensed home cultivators are subject to, and so I always like to review people to our website. Great amount of resources there, but the important thing to remember is, one, if you want to do that as an individual, you do need to be registered with the department. We'll issue them a card, and there are limits on how much you can cultivate on your own. Enforcement is a little tricky on this both on this and on the illegal sales between individuals, because we as a department, we only have administrative authority. We have authority to take your card away, but for any other consequences or prosecution, that's really up to law enforcement, prosecutors to determine whether, with their resources and the circumstances, whether they would pursue any criminal consequences for going over your limits or violating the rules.
Amy, what's the website that you want to direct folks to?
Yeah, cannabis.mo.gov.
Given the popularity, I guess, of this new product that is legally on the market, so much so that they back up traffic at the dispensaries, there must be an awful lot of people who are growing marijuana on these relatively small plots.
I don't have the numbers with me, but it's actually a very small percentage of Missourians and a small population compared to, say, the number of individuals who are registered as patients. It's just a fraction of those patients who are home cultivators and a pretty small amount of individuals who are registered for home cultivation on the adult use side as well. But the traffic problem that you're seeing, those are people who are going to the dispensary to buy the regulated product that has been grown by our licensed cultivators, produced by our licensed manufacturers. Individuals who are growing at home, they're not permitted to sell their product to or through the dispensaries.
Are there a lot of commercial people now who are licensed to sell? To grow and sell?
Yes. On the cultivating side, I think we have about 65. And on the manufacturing side, somewhere around 86 or 87. And on the dispensaries, more around 200.
Eric, could you paint a picture for us of what the production and supply chain looks like to supply the demand that clearly is there?
Yes, the cultivation facilities, Amy mentioned, they have a limit of 30,000 square feet of flowering canopy, it's called. That's one of the stages of growth of the marijuana plant. So there's a finite amount that any one facility can grow, and that's all with an eye towards we don't want an environment where there's oversupply, because that leads to things getting out the back door, that sort of thing, which no one wants. But it begins at the cultivation facility where the plant it begins typically as a seed or a cutting, a clone. A lot of the facilities will have mother plants, they call them, and then they take clone cuttings from them. And then because that mother plant has been established as reliable and produces premium flower and so on. And then it goes from the clone stage to a vegetative stage. And these transitions from one stage to the next are controlled by the light in the growing rooms. And so they sort of mimic the environment of the spring, and so it's the vegetative stage is just to make it grow bigger and stronger, so that when it moves to the next stage, the flowering stage, it will produce a larger volume and a higher quality of flower. That flower, completes its process, and then when it is ripe, I guess is the right word, they would harvest the plants. They go through a period where they're drying for 7 to 10 days, and then after it's dried, then they go into tubs and they're sealed for a period of 7 to 14 days to what they call cure. And also in that process, I omitted trimming, so that to remove all the stems and the other pieces like that. And then that flower can be packaged up and sent directly from the cultivation facility to the dispensary facilities where it can be sold as smokable flower. The rest of it, basically the buds that are not as large and attractive, and all those trimmings, all the other parts of the plant are biomass. Those things can all be sent to the manufacturing facilities where they go through machinery that extract out different cannabinoids from those plant materials and then convert them into a distillate. And then that distillate can be used to produce chocolate bars and gummies and vaporizer, pen cartridges, or any other kind of, basically any product in the dispensary that's not smokable flower. That comes from a manufacturing facility.
Eric, is this mostly a greenhouse type of operation as opposed to a farmer setting aside little gardens plot out by his field to grow some extra income producing crops? Is this indoors or outdoors?
It's mostly, at least in Missouri, indoors. Mm-hmm. And under the rules, a cultivation facility can choose to be an outdoor grow. It can choose to be a hybrid grow, where it's some outdoor, some indoor. It could choose to be, I guess, a version of indoor using greenhouse type technology, or it can be purely an indoor grow. And that last category is the most common one you see in Missouri, and that's mostly the product of our climate. We're just not well suited to growing year round. We're just not, the environment is a little too humid and a little too hot for the plants as compared to, the Pacific Northwest or Northern California, where it's basically perfect and they can grow outside very, very effectively.
If I have a greenhouse and want to grow marijuana, how many crops a year can I count on getting, do you think?
The professional cultivators can usually turn around 5 crops per year.
Wow. As a having been a farm kid, this sounds like a very sophisticated agricultural process. Is this kind of do you think that's fair to say? Like, we talk about agriculture being the number one industry in Missouri. Is this contributing to that industry overall?
Yeah, I would say that it is. And on the level, on the topic of sophistication, I believe it is staggeringly sophisticated. And I think when people tour these facilities, like I did for the first time at some point, you're really thrown off. I think people have the perception of the industry. They have the perception of the people who are interested in marijuana. And I don't think it applies to a great extent to the operators in the state, my clients, the licensees that Amy oversees. I think they're very serious about it, and they understand that millions of dollars have been invested and that there's a responsibility to operate these facilities the right way. There's an obligation to operate them in compliance with the law. And there is an incentive. I think almost all my clients would agree that there's a very serious incentive about saying we want to put out high quality product. We want to put out product that aids people with medical conditions if that's why they're consuming. And the level of detail, the level of technological advancement that is brought to bear on these grow operations and manufacturing operations is very impressive.
Amy, what's the difference between obtaining medical marijuana and recreational marijuana? I assume you have to go through some steps to get a prescription to begin with. But in terms of just going to a dispensary, can I get my medical marijuana at the same place I get my recreational marijuana?
Yes, in some states there are quite a few differences between the products themselves, where they're accessible. Here in Missouri, there's not a lot of difference. So setting aside the actual, individual licensing process, going to a physician, getting a certification, doing the application for a patient, the real differences are very small. If you go into a dispensary here in Missouri, our dispensaries, after the new law passed, they had the option to convert from a medical facility to a new type of facility called a comprehensive facility. Comprehensive facilities can serve both medical and adult use populations. There are no differences between the products, so you don't go into a dispensary and say, show me your medical products. There's no distinction between them. Now, they might have some that for their own reasons, they market as this is for the medical community, and we can tell you about things you might be interested in as a patient. But there's really no distinction, and we can't require that they make a distinction between medical and adult use products. The biggest distinction is the tax rate. So for medical patients, if they go into a facility, they can choose their product. When they get to the register, they will have a 4% tax applied to their product. As an adult use consumer, you go to the dispensary, you might pick out the same product, you go to the register, there is a 6% tax on that retail product that goes to a particular fund that supports the department and then goes to particular beneficiaries. There also could be local taxes on top of that. I was going to say the normal average sales tax rate in Missouri, I think the base is around 8% or something, and then there can be local taxes on top of that. So is the 6% then on top of all of that? It is. So you have all your regular retail sales taxes, whatever applies to other products in your locality. Then for medical, there's 4%. For adult use, there's 6%. And on adult use, there can also be an additional 3% on top of that for a local area. There's some dispute right now about whether there can only be one additional 3%, or if you're, say, in a county and also a city, can there also be an additional 3%? That's something, I don't know if Eric wants to talk about that, but that's something that will need to be sorted out in the courts and is in the process. I was going to say, one of those potential unintended consequences of the language as it was drafted in the constitutional amendment passed.
Yeah. Or it's the old philosophy of allowing a sin but tax the devil out of it.
Yeah. Bob, I think you're onto something there. And I can speak to that if you want to hear more about the tax stacking issue.
Sure. Yeah.
Well, we are representing a dispensary who's situated in Florissant, Missouri, which is an incorporated city in the St. Louis County. And what happened is the city of Florissant, through the process to impose a local tax, requires a vote of the people. And so it was on the ballot for Florissant, and it passed. They said, yeah, let's put 3% on there. And it was on the ballot for St. Louis County. And St. Louis County also voted to impose a 3% tax. And the way that the Constitution reads is, any local government can impose this tax if the voters approve it. Well, we go over to the other part of the Constitution where it defines local government. And it states that the local government is, in the case of an incorporated area, the city, town, or village. Or, in the case of an unincorporated area, the county. So it's plainly a binary situation where there is but one local government. Otherwise, you run the risk that one local government says, you can't be open on Sundays, and the other one says you can be open on Sundays. How do you decide? There's only one local government. Now, as it were with my client in Florissant, obviously the Florissant tax is fine. And the county having passed it is absolutely fine because the passage of that vote and the imposition of that 3% tax is completely appropriate for dispensaries that happen to be situated in unincorporated areas of St. Louis County. And there are many. And so in those places, the 3% should be collected. But it's unfair that down the road, the competing dispensary that happens to be situated within a city, town, or village, they have to impose the 3% county tax and also the city's tax if they've passed one. And so that's the current state of affairs. And we have filed a lawsuit in St. Louis County Circuit Court where we are asking the judge to interpret that language and give direction to the Department of Revenue.
It sounds like from some of this discussion that for some people, marijuana is priced out of their price range because of the taxes. Have you heard any complaints that people can't afford marijuana?
That is a constant concern, and I have seen, it's all anecdotal, but in newspaper stories, particularly around the tax stacking issue this past year, we've seen people who said, boy, I'm fine with, a reasonable tax, but this is just too much. I'm going to go back to whoever I was buying from in the past who doesn't hold a license from the Department of Cannabis Regulations, or Division of Cannabis Regulations. So it's a real problem. And as I said, the largest seller is always the illicit market. And I can tell you that my clients take the view that their goal is to try and beat the big competitor. Their goal isn't to create new cannabis consumers. There's plenty of demand. They just need to persuade those consumers to come over and buy from the legalized market. And as with so many products, the challenge is to compete on price. My clients simply can't. They can offer service. They can offer safe products. They can offer convenience. They can offer a wide selection. But they can't match the prices that the illegal market can offer.
With these additional taxes and other regulations, does that make it a steeper kind of learning curve or starting curve for those who decide to be pioneers in this business in Missouri, whether they're a small business owner or a corporation? Does it add additional layers for them to have to discover or learn how to operate within as they start this business?
I think we have a lot of very sophisticated operators. They come from a variety of backgrounds, but most of them came into this business with financial backing, with a lot of business experience, some even with experience being in other regulated industries. So this is a highly regulated industry. The Article 14 puts a lot of emphasis on things like tracking product to ensure that it does not go out the back door to the illicit market and that illicit market product does not enter our regulated market. There's a lot of emphasis on security, testing of product to ensure that it's safe. So there is a lot of expense related to being in this regulated market, but that's similar to other regulated markets. And I think that we have some really great licensees with their background, with their experience, pulling their teams together. Yes, it's all new and it is a lot to learn, but I think they've done a great job of getting started and just right off the bat being a really impressively compliant industry.
Enforcement is an issue that comes to my mind. You folks are in the regulatory position, but do you have any enforcement powers within your division? Or do you rely entirely on the local police and sheriff's departments that like to enforce the law?
Yes, so our authority is administrative. I mentioned that for the individuals who hold a card, but it's also for our licensees. So our biggest authority for the most egregious situations would be to revoke their license. There's a lot of motivation to stay compliant so you don't lose your license. It's an incredible asset, the license itself, and once it's revoked, there is an appeals process for that, but nobody wants to get that far. Before we get there, we can issue notices of violation with remedial actions. We have the option for certain penalties. So there are a lot of tools for enforcement, but there's definitely a line that we have to draw between us and law enforcement. And so if we receive any information that is more in law enforcement jurisdiction, we can refer that, but we wouldn't be able to act on potential criminal infractions ourselves.
Is there any training for local law enforcement on how to enforce these laws?
Yes, I know that local law enforcement, highway patrol, they have organized their own training, and then also we have been giving presentations and training since the very beginning. Really, anybody who reaches out to us who wants information, who has questions, we will respond. If they want us to come and present, we will do that. We always find somebody who can go and provide whatever information we have that's applicable to their request.
Have you had very many license suspensions or revocations?
A few, right? We've had a few suspensions. We've had a couple revocations. It's very rare. No one wants to get that far.
I know with alcohol licenses, I don't know if they still do this, but I remember a time when they would limit the number of alcohol sales licenses that were eligible. Like, I don't know if it was per county or per region. Is there a limitation, or if anyone meets the criteria, are they able to be licensed to be a distributor?
Yes, so there are limitations for all of our facility types. That was written into Article 14. There were a minimum number of licenses that we were to issue, no matter what, and then it was left up to the department to determine whether or not we would issue additional licenses of any facility type and to what degree. So we did a lot of research and analysis early on before issuing the initial round of medical licenses, determined that weighing all factors, there were many more dangers and costs related to having oversupply than any benefits to having unlimited licensure. They were the kinds of costs and dangers that Article 14 required us to pay attention to as well, such as with oversupply, there's a lot of motivation to divert product to the illicit market because, of course, you want to recoup your costs. And then there's also generally lower compliance when you have unlimited licensing based on just minimum standards. There were a lot of reasons, a lot of regulatory costs included in regulating unlimited licenses. The more costs we have on the government side, the less the beneficiaries of this program receive. Long list of considerations. We determined that we would have much more supply than demand, even with the minimum number of licenses, so we decided to stick with that number. We do have to pay attention to that. The law requires that we lift or ease our limits on licenses in order to meet demand. With the new law, it also throws in another consideration, says in order to meet demand, but also make sure that you're not issuing an over-concentration of licenses in any given area. So there's an analysis to be done. We have to ensure that we have enough licenses to meet demand, have to make sure, though, that we don't issue too many in any area. So it is something that we look at about annually. And as of right now, the capacity in our currently issued licenses is still greater than the expected demand.
Eric, from the industry standpoint, do you see people being able to enter the industry that have the resources and means to do so?
Yes. If someone has the resources and the means to enter the industry, they can. I have not seen evidence that we're at a point where everyone who has a license is now completely unwilling to part with that license. There's still a lot of transition. There's a lot of movement among these licenses for people taken it this far and they decided this is not for them, or they, the competitive environment is too intense and they don't feel like they're on a good trajectory, so they decide now is the right time to sell. So we do have that not infrequently, where new operators typically operators who've been successful in other states are saying, Missouri seems like a good state. It seems like it's well regulated. It seems like a good market, and they want to come here and operate. And a big part of that is the stability that license limits furnish. In other states where it's unlimited licensing and you can get one as easily as you can a fishing license or something, it's just a disaster because it becomes a race to the bottom. Everyone has to try and just compete on price because everyone can make great products and market them and so on. So corners are cut. I think regulatory corners are cut, which is not great. And it really, in Missouri, would be unfair from a sort of market stability and a capitalization standpoint, because people made many, many millions of dollars in investments in these licenses. And those were all premised on the idea that this is a limited license market and there's going to be approximately this many licenses. And that's allowed these licenses to have inherent value and for them to be the basis for these investments. If that environment suddenly shifts and now everyone can get a license, the licenses, their inherent value will basically evaporate. In some states, you can't give away your licenses. You have your building and your equipment, those would have value, but the licenses themselves no longer really have value because you can just go get another one. So I think it is important, and I think that DHSS has taken the right approach in terms of maintaining reasonable limits, and Amy's absolutely right. There is additional capacity within the industry. Some of that is being brought online, and there's not really a problem as far as meeting the demand.
Eric, should I invest my 401k in this business?
Would not recommend that. I'm not your wealth advisor, but it is a risky proposition, and I think the people who say, well, shoot, this marijuana industry, it's like printing money. This is easy. I'll just put my 401 in it and it'll double or triple. That has not been the experience of, I would say, almost all of my clients, because it is, as I said, it's a very intense competitive environment. It is a very expensive operation to run in terms of material, in terms of people. Employees are very, very well paid. Most of the jobs have benefits. And so you have to do it right to get the good people. You have to do it right to market your products effectively in this environment. There's a lot of regulatory costs. And then with the tax burdens around it, it ends up that it's very difficult to show a great deal of profitability.
With the proliferation of recreational and medical marijuana states, is the federal law on marijuana no longer valid or no longer worth paying attention to?
That's a tough question. I wouldn't say. I wouldn't say. I'll let Amy answer too, but I would not say that you can ignore federal law. But federal law is sort of ignoring the states is one way to think of it. Okay. As to medical, there's a provision in the federal budget that says DOJ, Department of Justice, to the extent we're giving you this money, you cannot use it to interfere with the implementation of a state's medical program. So as medical operators, there's an explicit sort of protection. There isn't the case with adult use operations. That sort of language isn't in there. It's essentially left to the discretion of each of the U.S. attorneys in the 91 or 93 districts around the country. But, in my understanding right now, uniformly, they all have more important things in their estimation to attend to with their limited resources. And so if you're in compliance with your state laws, I think it's safe to say the federal government doesn't have any grave concerns. And there is sort of incremental progress towards a future day when the federal government decides that it shouldn't be, the marijuana shouldn't be on Schedule 1 of the controlled substances list. But the day is not yet here. Amy, what do you think?
I agree with that. I think everyone is relying on the recent history where the federal government just hasn't acted. And I think that reliance has proven to be reasonable. Everybody's counting on it and proceeding, accordingly. It's working out. I do think that there are indications, as Eric said, of movement toward more acceptance. Now, what form that will take, we don't know. But the conversations at the federal level are not about trying to shut this down. They're about what steps should we take to ensure, for instance, that these legitimate state businesses that are following a state law have access to traditional banking. That's one. And when there is any, for podcast people, I'm not going to get into that subject. Never mind. So our states across the board are not seeing any federal action anymore. And, in the cannabis world, distant past is more like a couple decades. But in the distant past of this cannabis project that everybody's embarking on, there was some federal action. It's just not happening anymore. So I think it's safe to say that we'll just keep going and we'll see what the feds decide to do, probably in bits and pieces, to change the federal landscape, which will be very interesting. Everyone in cannabis regulation and the cannabis businesses, they're used to change. But once we start to see some action from the federal government, piecemeal or not, it has the potential to really impact the states. So we're used to change. That'll be a big one. It's just never ending here.
I want to switch gears. We've talked about sort of the industry standards and overall regulation. I want to get into what the average consumer needs to know about purchasing and using adult or recreational marijuana. Who can buy recreational marijuana in Missouri?
Anyone 21 and up.
And you don't need a card to do so?
You do not. You do need a card, as we talked about before, if you want to cultivate at home. But if you're 21 and up, you can just walk into a dispensary and purchase up to the purchase limits, possess up to the possession limits. You don't need any special authorization.
You have to have a driver's license or something that shows you're 21, though.
You do, yes.
Yeah.
Are there any limits to how much can be purchased over a period of time? So I know that you said you can't go in and purchase in one setting, but, over a month, if I go every day, are there limitations?
There are limitations for patients over periods of time. It's a rolling limit. But for adult use consumers, the law put it at a per transaction limit.
Okay, so I could even go more than one time a day as long as it's a different transaction, I guess.
Well, there is a concern about a practice called looping, which is basically what you describe, going out to the parking lot, coming right back in. That is something that we keep an eye on. We do have a rule that requires dispensaries to essentially watch for that and report if they observe that happening. For us, that would be something that we would refer to law enforcement, and then they can decide whether they want to investigate that. Because, of course, the concern is that somebody that's doing that is going to have a large amount and is likely planning distribution of that. So it's something to watch for, something to refer to law enforcement, and then they can investigate if they wish.
Is there the prescription drug monitoring program keeps track of all kinds of things? Does marijuana fit into that too?
We have our own tracking. So the law required that we track all product from seed to sale. This is very common in other cannabis regulatory states. I think almost all of them, if not all of them, are engaged in this effort at this point. And the idea there is if you're tasked with ensuring that your regulated product doesn't go to the illicit market, and if you're tasked with testing your product, it's very necessary for both of those efforts, which we are doing in Missouri, to ensure that you can follow a product from its immature plant stage or seed all the way through all of the phases that Eric described earlier, as it moves through a cultivation facility, as it spreads out to manufacturing facilities and becomes part of other products, and then as it goes to the dispensary all the way to sale. There's so many benefits to having this tracking system. You can look then for red flags to see if any product is missing. You can look for red flags to see if any product suddenly appears. That's the basis of your representative sample for testing. If you know how much you should pull out of a bunch of cannabis in order to test it and see if the test results are representative of the whole, you have to know what's in the whole, right? And then ultimately, if after sale, someone were to have an adverse effect to consumption of that product, or if there were other issues with product that was discovered at any stage, that tracking system allows us to perform a hold on any related product or a recall on any related product. It can trace all the way back and see throughout the entire market what products are connected to the product at issue that has some kind of problem. So it's very valuable for us to have that tracking system, also required by law, so we're going to do it.
So does the department have people who go out and do this tracking or do this testing, or who does that?
So the systems are built to have plants and products tagged. There are a couple different mechanisms, ways to tag plants and product, but then it's a data game. You can track through those tags on plants and products through the IT system. It follows the data as it moves through the systems. Our task is to monitor the data itself. For red flags, problems, our people are the ones that can do the holds or the recalls. They also, in inspection of the facilities, they will do inspections to ensure that everything in the facility is properly tagged so that we're not missing anything.
Eric, I thought I heard you want to jump in here a minute ago.
Yeah, I was going to talk about some of the differences, and you talked about the tracking and the purchasing and so on. In Missouri, it was similar to other states. When the adult use program was launched, the market demand, the amount being purchased, roughly went up by a 3 multiple. And so from about 40 million overall in sales on a monthly basis to about 120 million on sales. And that increment of new buyers, consumers, are people who didn't get the patient card, some of whom maybe wouldn't qualify, but probably many of whom would. Those adult use consumers, when they buy, their names aren't written down. Yeah, they have to show the ID that they're old enough, but there's no record that it was, John or
that was going to be my next question.
Who went in there. Yeah, that is off the books. And that's the way I think some people want it. Yeah. And that's the way that I think some of the people who might otherwise qualify for a patient card, they say, well, I don't want to be on, the grid. I don't want, Big Brother watching me, this sort of thing. But there is a benefit to people continuing to get a patient card if they qualify. Because, one, there's the lower tax benefit. That's one aspect of it. But another aspect of it is that the way Article 14 is written, and maybe the courts will interpret it a little differently, but there are not many protections for someone who is choosing to consume marijuana on their free time. There'll be no law, no state anywhere that's going to say, well, you can go to work as high as you want. That's ridiculous. But, the problem is some perceptions of the product still say, well, we don't want you to consume it all. And now I understand that if you're driving the school bus, for example. I don't understand it if you're driving a desk. If someone wants to have a drink after work, that's okay. If they want to be able to consume a marijuana product after work, it seems like that should also be okay. So the reason I say all this is that if you have the patient card, there are some additional protections built into Article 14's language that would say, the fact, for example, that you have a patient card. You can't be discriminated against. You can't be subject to adverse employment decisions, different things like that. So there are some significant protections, I think, for people who have the patient card. And that's probably makes it worth doing, I think, for a lot of people.
Building on those protections, a question about what rules can employers set for use of marijuana in or outside of the workplace?
Well, those rules are less than clear. And it's mostly derived from language in Article 14. What, considerations I think for employers are, if you wanted to try and have an absolute prohibition, I think that may be subject to challenge. I think you would also perhaps be hurting yourself by limiting the pool of applicants, particularly in an environment like now where there's a pretty low rate of unemployment. People just say, well, I'm not going to work there. You know, that's a problem for me. And so that's one consideration. But, you know, if you're going to have a zero tolerance program, you also have to have a testing program. There's a cost to that. There's a burden to that, making employees unhappy. Again, we're talking about a competitive hiring environment where it does make sense and where the law recognizes those kind of policies having some sense is if you have federal contracts, because of the federal prohibition, there's still an expectation that you have a zero drug tolerance environment. And then the other is in what they call sort of safety sensitive jobs. I mentioned like school bus driver, crane operator. In those instances, there's still some accommodation in the law to say, well, we're going to allow you to just say that this person who's swinging the crane and knocking down buildings and stuff, that we don't have to tolerate them wanting to consume even off duty. Now, it begs the question, why would we say we're just as comfortable, though, with that person being able to consume alcohol? That person maybe has a prescription for opioids. You know, those kind of considerations don't come to bear, but they do for the marijuana product. But again, it's understandable.
A lot of employers allow their employees who still smoke cigarettes to take smoke breaks as long as they go outside and stand on the porch or stand on the sidewalk or something. If you have an employee who on his or her smoke break goes out and enjoys a marijuana cigarette or something, and then they come back and the employer over time decides that this person's job work is their work product is impaired because of their smoke breaks. Can an employer fire somebody because they go out and smoke marijuana on their smoke breaks and their somehow job doesn't seem to then measure up?
Yes, that's the bottom line. There is no legal protection for that type of activity any more than somebody who wants to go outside and you know, drink out of their flask. Again, people go to lunch and have a beer sometimes or a drink and then come back to work. It's a question of, you know, what's tolerable. I'd say maybe, Bob, the only fact pattern I could think of is if it is a record store or some other place where having high employees doesn't seem to be a big problem. And the employer typically and routinely accommodates people who want to go out, and everyone's going out and having that kind of a smoke break. Yeah. Then you wouldn't be able to say, well, hey, you're a marijuana user, so you're fired. Yeah. That would be treating people inconsistently, and there'd be a claim for that person, I believe.
Yeah. How is drug testing in the marketplace changed because of the change in the law?
In my view, it's changed in the sense that people are abandoning it, at least as to marijuana, because it's really ineffective in an environment where marijuana is not illegal. And so if you're testing to find out if someone was hurt with, you know, on the job, and so for work comp purposes, you know, well, we're gonna put them through a drug test. Well, the drug test would only show that the person has certain elements in their blood. I don't remember the exact word for it, but as marijuana is broken down within the body, it leaves, you know, these telltale elements that are detectable in these tests. But for someone who is a heavy regular user, if they were to suddenly stop, they could be tested as far out as they've shown 35 days later. They would still test positive, potentially. And the average is more like, you know, 5 to 7 to 9 based on basically how frequently, how often someone smokes, and the percentage of body fat they have. That's where these markers are stored in the body. So, yeah, testing somebody that was in a workplace accident and they test positive, it doesn't mean that they were impaired. It doesn't mean that they were working on the job while under the influence. It only means that in the somewhat recent past, they consumed. So in the workplace, Bob, what is developed in some states and in Illinois, it's been placed into their statutes. There's sort of a safe harbor for employers if they train their supervisors to look for telltale signs of marijuana intoxication. And that kind of sounds and looks a little bit like a field sobriety test. If it's someone's, you know, acting high, they can't, you know, avoid laughing inappropriately. They can't maintain their balance when they walk, you know, different things like that. That coupled with a positive drug test can be enough to say, okay, you were intoxicated on the job, you know, that contributed to your workplace injury, or that's a basis for us to terminate you.
Is it fair to say that if you're a business owner and you haven't updated your employee handbook and policies since recreational marijuana became legal in Missouri, that's something that you probably should be looking at now.
Absolutely. It's very likely you may want to refine your policies. And again, this is not to say you should get rid of your anti-drug or zero tolerance type policies as to other drugs that haven't been made legal by, under the Missouri Constitution. But as to its applicability to marijuana, there's a very good chance if you haven't updated it, you might want to.
Beyond being at work, are there any rules or laws about being high in public or consuming marijuana in public?
There are some prohibitions in Article 14 about consumption in public. It may be specifically smoking in public, but there are also some interesting carve-outs for local governments that wish to have something different. They can choose to set their own standard for public consumption. Eric, I don't know if you're aware of any specific examples of local governments having done that.
Yeah, I will confess I haven't studied it recently. I don't know, but I'm fairly certain in the city of St. Louis that they have passed an ordinance that creates a pathway for businesses to apply to operate as a consumption lounge, if you will. And now that has to be reconciled with liquor laws, for example. There was a regulation that was promulgated, I think, sometime last year. And it essentially said that, if you have a liquor license to operate a bar, you cannot also allow marijuana consumption on site. And so there was some effort to try and massage that language a bit to I think the current regulatory environment would say if you have a bar, you can't also allow for consumption, but you could choose to have like marijuana consumption night and not sell any alcohol, not utilize your liquor law. And there's some science to that concept that there are a lot of studies that show that mixing alcohol and marijuana is sort of the worst way to go. In terms of like drunk driving studies, things like that. They've shown essentially with marijuana consumption, there's not a remarkable or substantial increase in any incidence of problems. But when it's combined with alcohol, it's higher than even the incidence of problems with just alcohol alone, which is significantly higher than just marijuana consumption alone.
When we talk about being in public, what does that actually mean? Like, can you smoke marijuana in your vehicle, inside your vehicle, if you're parked in a public parking spot? Or is it one of those, it depends answers?
Yeah.
I'm just trying to get Bob to say hot boxing on the show, so.
The answer is I am not entirely certain. I know that generally there's language in the Constitution that says, if you smoke in a public place other than an area licensed for that activity, you can be subject to a civil penalty. But that language is in part to decriminalize. I'd say that's the maximum consequence for smoking in a public place. Civil penalty not exceeding $100. So that kind of a limitation. Certainly the concern with a car would be if someone is driving. That is explicit in the Constitution that driving or driving a boat or anything else like that while under the influence is absolutely prohibited.
That does, though, bring up kind of a related issue. And as a person who doesn't smoke, but I walk into a place sometimes where people have been smoking cigarettes, the secondary smoke issue comes up here. And so if I walk into a place, whether it's public or private, and the room is filled with secondary marijuana smoke, is there any liability that might stem from whatever effects I might incur from secondary marijuana smoke? How does that fit into this picture?
That's a really good question, a good fact pattern. I don't know. I'm not sure that I could even answer that question as to cigarette secondhand smoke. I know there's all the studies that demonstrate that it can be very harmful. And I don't know if the same studies would apply or confirm that result for secondhand marijuana smoke.
I sense a third program here.
Yes.
We'll see what the data unfolds over years of legalization. Are there any penalties, or is it treated the same if you're driving under the influence? We usually talk about driving while intoxicated. When it comes to alcohol, is that also a potential risk that people should consider for marijuana use?
Absolutely. The Constitution states there's no immunity of any kind for, if you're operating a vehicle, an aircraft, a dangerous device, I'm not sure what that, a chainsaw, I don't know, or navigating a boat, whatever, under the influence of marijuana. It is, driving while impaired, driving while intoxicated, however you want to call it. And it's without regard really to whether it was alcohol or marijuana or cocaine or some other substance.
And I'm guessing that there are also penalties. I know that you talked earlier about sharing, but, in Missouri, you're not supposed to provide underage individuals, under 21 with alcohol. I'm guessing that there's similar limitations with marijuana.
Absolutely. The sharing can only happen between adults 21 and over. It's very explicitly prohibited to provide marijuana to someone under 21.
We're kind of winding down the program because we've been at this a long time, but I do have one thing I want to ask you about. Are you hearing from schools any reports of increased students being high coming to school because this new law is in effect?
I will say anecdotally, I've heard both. Mm-hmm. I've heard some educators concerned about what they perceive as an increase of use among minors. But I also hear of pretty trustworthy studies showing that marijuana use among children or minors is not significantly increasing. I also think there's a cultural element to this, so it varies state by state. We haven't really been at this long enough in Missouri to produce any good studies, and I don't know. I'm sure people are looking at it, but I haven't heard of any results related to Missouri. So I don't know what the answer is about whether use of minors is really increasing significantly or at all in states that have legalized.
Yeah, I imagine both of you might respond to this. I imagine 5 years down the road, we'll have a much better picture of where we are with medical and recreational marijuana and its benefits and its side effects, and whatever changes in law might be necessary.
There are some really interesting national studies that are studying the professed beliefs of minors and of parents about usage, about health of usage. And really what I hear more about with young people is increases in vaping, whether that's tobacco or marijuana, that there's some strange perception of health related to vaping when that's just not the case. But I don't hear that there is a increase in young adults or in minors of a perception of health related to cannabis. I'll be interested to see where that research goes.
Yeah.
Bob, I'd like to add to that. I'm looking at a study I've looked at before from the National Institute of Health, and they've done these surveys over the years with different students at different age levels. And the conclusion in this study I'm looking at says that after recreational cannabis legalization, when asked about the previous 30-day cannabis use, the prevalence among 8th graders was that the use had decreased by 22%. And grade 10 prevalence decreased by 12.7%, and that there was really no effect in grade 12. But what's more interesting to me is it said these trends are consistent with those in states without recreational cannabis laws, suggesting legalization did not impact adolescent use prevalence. So whether or not it's legalized, it seems that the trend is downward. And my personal theory on that is now that it's not illegal, now that it's this boring back pain alleviation medication that your uncle takes, it's not as cool.
I also have a personal theory that the regulators are doing a good job. So in almost all of the states that have legalized, their law includes some mandate or suggestion to the regulators that they should pay attention to ensuring that the products produced by a legal market are not appealing to children or minors. And so perhaps also we could give the regulators a little bit of credit for starting out at the gate, thinking about that and ensuring that there's communication and mechanisms in place to protect kids and young adults.
I was traveling last week, and at the airport layover that I had in Chicago, I noticed that they had these large green metal boxes called marijuana amnesty boxes.
Yes, I've seen those.
So everything that we've talked today, all of those rights and rules and procedures and laws, it stops at our state border. Is that right? What advice would you give to Missouri consumers who are maybe planning to, go across the border to Illinois or Kansas or any of our other 6 neighboring states?
The simple advice is interstate transport of cannabis is still not legal. For what that's worth, people can take it for their own personal decisions, but that is definitely absolutely true. Whether it's being enforced, I don't know. Eric, have you heard?
No. I mean, I think, kind of as I said before, with the U.S. attorneys and the federal marshals and so on, they're not going to be stationed on the bridge. That's not their bailiwick. You do hear about, for example, there was a banking institution in Colorado, as I understand it, and they offered to provide services to a licensed operator in Missouri. And so they came and they picked up a bunch of cash, and then they planned to transport that back to the institution in Colorado. Well, that truck was stopped in Kansas. The Kansas law enforcement had some awareness of this, and so they stopped it on the basis of interstate trafficking and possession of, proceeds of scheduled narcotic sales and different things like that. So I think that's where you might see more interest. I think the consumer who has their, personal amount with them, and they go and drive from Missouri to Illinois, there's no problem. It's legal in Illinois. Now, if you drive over to Kansas, it's still prohibited, the possession of it, the consumption of it. So maybe some.
Is a prescription a get-out-of-jail-free card?
Well, it would not protect you from possessing over the legal amount here in Missouri. But if you have either a Missouri medical card or a medical card from another legalized state, then if you are stopped in possession, that card will show your authorization to possess the legal amount.
But in a non-legalization state?
No, I don't think that would work out very well.
I know we've covered a lot today, and in closing, I just want to ask both of you, what do you believe the average citizen should know about recreational marijuana here in Missouri? If there's one takeaway that you would want, every citizen in the state to know or understand about it, what would it be?
I would say the regulated product goes through a lot of oversight. It goes through testing. As much as we know about cannabis, we are trying to make this product safe. There's still other product out there, illicit product. There's product made from hemp. There's a lot of other THC products out there. What I would say is just if you're interested in the safety of the product, knowing what's in it even, make sure you're buying from a licensed dispensary.
Eric, anything to add?
Yeah, Amy stole most of my thunder. I think that's the big thing that the average consumer should know and understand is if you're not buying it from a DHSS licensed dispensary, you're taking some risks. You don't know what is in that product. You don't know where it was grown or how it was grown. It's very, very likely that it wasn't tested. And that holds true even in places that purport to be dispensaries. There's different businesses out there, and they're claim to be a dispensary, and they're selling hemp-derived cannabinoid products that have an intoxicating effect. And you'll see them. They talk about, federally legal THC, because basically there's a loophole that allows for the creation of these products. But there are none of the regulatory frameworks and oversights that Amy's division implements to ensure that those products are safe. And the industry is concerned about it, again, because that erodes the market. That, in some ways, misrepresents the market to people because it isn't necessarily a safe product. It isn't necessarily packaged safely. It is packaged in ways that may be attractive to minors. And so we think that's a very big problem. And we've even purchased some of these products and then sent them to testing labs. And it reveals, heavy metals and all sorts of other things that would mean that those products had to be made in the regulated system. They wouldn't pass. They wouldn't have ever gotten to the dispensary shelf. So I think if you're serious about trying marijuana, or you want to know, what's in it or what effects it's going to have, you're better off going to the regulated shop. The people there can tell you about the different products and the different consumption methods and talk about maybe what medical conditions you're trying to treat. They're not doctors. They can't prescribe anything, but they can say, hey, our experience would show, our consumers and our patients have said this product helps with back pain, or this topical cream will help with, your tennis elbow, in our experience.
Before we go, this program series is focusing on a lot of our basic individual rights to shed some light on the U.S. Constitution and the rights we have under it.
Here's the Missouri Bar Citizenship Education Director, Tony Simons, to tell us more.
We've spoken on numerous occasions about the right of privacy that springs from the United States Constitution, how it's traced to the liberty provision of the Due Process Clause of the 14th Amendment. We have also discussed that while some justices of the Supreme Court find such an interpretation of the 14th Amendment totally acceptable, other justices believe that this puts the Supreme Court in a position of legislating from the bench. However, a judicial interpretation of the Due Process Clause is not the only source of a right of privacy in this country. Many state constitutions include an expressly guaranteed right to privacy for its citizens. This right of privacy is not a matter of interpretation. It is a matter of record in the state's supreme governing document. It would be the right of privacy, as guaranteed in a state's constitution, that would provide the first instance of constitutional protection for the recreational use of marijuana almost 50 years ago. In 1972, the Alaska Constitution was amended to include a right of privacy, stating, "The right of the people to privacy is recognized and shall not be infringed." Later that year, Irwin Ravin was arrested and prosecuted for possession of marijuana, a violation of Alaska's criminal code. Ravin challenged the constitutionality of the law, arguing that criminalizing the possession of small amounts of marijuana for personal use violated the right of privacy. Although Ravin based part of his argument on the federal right of privacy, he also relied on the right of privacy explicitly recognized in the Alaska Constitution. In the 1975 case of State versus Ravin, the Alaska Supreme Court took up this issue, focusing its analysis on the right of privacy guaranteed by the Alaska Constitution. The court was not prepared to say that the right of privacy protected an absolute right to smoke pot. Instead, the court focused its attention on where the marijuana would be used, writing, "This leads us to a more detailed examination of the right to privacy and the relevancy of where the right is exercised." The Supreme Court of Alaska focused its analysis on the smoking of marijuana in the home, writing, "If there is any area of human activity to which a right of privacy pertains more than any other, it is the home. The importance of the home has been amply demonstrated in constitutional law." The court went on to write, "In Alaska, we have also recognized the distinctive nature of the home as a place where the individual's privacy receives special protection. This court has consistently recognized that the home is constitutionally protected from unreasonable searches and seizures, reasoning that the home itself retains a protected status under the Fourth Amendment and Alaska's Constitution, distinct from that of the occupant's person. The Privacy Amendment to the Alaska Constitution was intended to give recognition and protection to the home. Such a reading is consonant with the character of life in Alaska. Our territory, and now state, has traditionally been the home of people who prize their individuality and who have chosen to settle or to continue living here in order to achieve a measure of control over their own lifestyles, which is now virtually unattainable in many of our sister states. The court concluded, the home then carries with it associations and meanings which make it particularly important as the situs of privacy. Privacy in the home is a fundamental right under both the federal and Alaska constitutions. The court viewed that privacy as protecting what a person would read, what a person would watch, and what a person would smoke. Against this fundamental right of privacy in the home, the Alaska Supreme Court considered the state's interest in prohibiting the smoking of marijuana in the home. The court found the state's case insufficient, writing, the authority of the state to exert control over the individual extends only to activities of the individual which affect others or the public at large as it relates to matters of public health or safety or to provide for the general welfare. We believe this tenet to be basic to a free society. The state cannot impose its own notions of morality, propriety, or fashion on individuals when the public has no legitimate interest in the affairs of those individuals. However, the court noted that the right of the individual to do as he pleases is not absolute, of course. It can be made to yield when it begins to infringe on the rights and welfare of others. The court identified as unprotected by the right of privacy the public possession or use of marijuana, driving under the influence of marijuana, buying or selling marijuana, possession of larger amounts of marijuana that indicate an intent to sell, and the use or possession of marijuana by minors. Barring these conditions, though, the Alaska Supreme Court was willing to rule that a right to privacy found in the state's constitution protected what was, in the eyes of many, a crime. Under our constitutional system, states are allowed to use their constitutions to provide more protection to its citizens than are provided by the United States Supreme Court interpreting the Constitution. It will be interesting to see if this principle experiences a renaissance in the coming years.
Nothing further, Your Honor.
We want to thank Amy Moore and Eric Walters for being with us on this special edition of Is It Legal 2 today. Thank you both for being here.
Thank you.
Is It Legal 2 is a special production of the Missouri Bar, and we're grateful to the guests that we've had on this program as well as others. This has been a fun experience for me.
Indeed. Again, thank you both for joining us today. And there are some resources you might want to check out and explore on this topic and more. Just go to Missouri Lawyers Help, that's all one word, .org. You're going to find an array of other information on this and various other legal topics at that site. The site provides information that will help you better understand the law, because the more you know about the law, the better decisions you can make for your life, your family, and your finances. Again, that's MissouriLawyersHelp.org. I'm Farrah Fite.
And I'm Bob Priddy. We'll see you on the next edition of Is It Legal 2?
Opinions and positions stated by guests and presenters in the Is It Legal To podcast are those of the guests and presenters, and not necessarily those of the Missouri Bar. This program is intended as information for lawyers and citizens of Missouri in conjunction with other research they deem necessary in the exercise of their independent judgment.